Thank you very much. Good afternoon, everyone. Thank you to Equinet for having us today. During this presentation, we aim at presenting the findings of a report that we have published for the European Commission on algorithmic discrimination, challenges and opportunities for EU gender equality and non-discrimination law. And so here is our plan for today. We first will have a brief look at what algorithmic discrimination is in the European context, and we will then offer an overview of the challenges that it poses both at the EU but also at the national level. And fourth, we will explore some solutions and opportunities for enforcing algorithmic equality. And with this, over to you, Janneke.
Sorry, I forgot to unmute. But thank you very much, Raphaële, and also thanks to the organizers for inviting us. And I think it's clear already from the remainder of this morning's sessions and also from Sandra's wonderful presentation that there is a lot of reason to be concerned about the discrimination that is generated by algorithms. And well, of course, even though Sandra has just provided us with an excellent introduction, I'm not sure if all of you are too familiar with what algorithms are and exactly how they can cause discrimination. So I'd like also to give you a little bit more information on how discrimination by algorithms works, but I'll keep this very short to avoid too much repetition. And of course, you know that this type of discrimination, so algorithmic discrimination, is well, increasingly pervasive in our societies. And of course, we will tell you more about the use of algorithms in Europe later on, but just to give you an impression, I'd like to mention a few examples of algorithmic discrimination that almost all of you will know. And one of them is an algorithm that Amazon had developed to support its own human resource management. And that in fact resulted in many more men being promoted to higher functions than women. And another example is that facial recognition algorithms may be better at recognizing white male than dark female features. And also that may possibly result in discrimination. Or you may think of Apple Card, where an algorithm was used to the effect that higher credit limits were given to men than to women. And of course, there are many more examples that may be provided, and they all clearly reflect stereotypes and structural forms of discrimination. So in fact, it's clear that the use of algorithms often results in discrimination, but then the question is how that is possible. And as mentioned, I will not actually try to explain to you how algorithms work today. And I think it might be sufficient to note for now that there are different types of algorithms as well. So there's one category that is relatively simple, and these are rule-based algorithms. And basically, these are computer instructions that well, relatively precisely mirror human decision-making procedures, and that can help to automatize decision-making procedures. Of more interest today, I think, are these machine learning algorithms and deep learning and artificial intelligence. So those can be used to process and analyze huge sets of data. So for instance, to detect these patterns or make predictions about individual behavior. And that is the kind of algorithms that were at work at the examples that I've just given, and also the examples that Sandra has mentioned in her presentation. And indeed, these types of algorithms are now increasingly used also in European countries. And as Sandra also has explained, one thing all these algorithms have in common is that they make use of large amounts of data. And one of the root causes of algorithmic discrimination is that such data can contain biases. And that's another core notion for today, of course. And well, to again, very briefly sketch how it is possible that there is such an inherent risk of discrimination and bias in algorithmic discrimination, I think it might be important to note that algorithms are planned, developed, and used by human beings. So for instance, in a company, a team may decide that it could be a good idea to start using an algorithm for recruitment purposes. And then they may hire ICT specialists to develop one. And once it's ready, human resource officers may use the output of the algorithm to help them in making decisions. And the point is that in all these stages, these problems of bias, stereotyping, and discrimination might creep in. So taking Amazon's recruitment algorithm as an example, it was clear that the data that were used to train the algorithm were reflecting historical discrimination stereotypes, and these were recognized as relevant by the algorithm, but this was not corrected by the persons applying the algorithm. So in a way, in all three of these stages, a combination of human stereotypes, past discrimination, structural inequalities may result in algorithmic bias. And as I mentioned, that even may be true if decisions are not made by the algorithm directly, but by a human being based on the output of the algorithm. So humans are very prone to cognitive biases, as we all know very well. And even if an individual intuitively may feel that the outcome suggested by an algorithm isn't right, he or she might find it very difficult to disagree with what the computer has told them. So that means that algorithms bring along a number of challenges. And in our report, we have distinguished 6. So first, there is this human factor that I've just discussed. So officers and employees may willingly or as a result of cognitive bias make discriminatory decisions in designing or using an algorithm. And second, there is this problem of data. So algorithms should be trained on correct, reliable, unbiased data sets, but these are very difficult to come by. Third, a particular issue with machine learning algorithms is that they may be very good at recognizing patterns and making predictions. These are all based on correlations. So for instance, these algorithms might find that there is this correlation between someone being a male nurse and having an interest in red sports cars. But it surely doesn't mean that there is a causal relationship between those two factors. And that example also shows that these highly fine-grained factors, such as a preference for cars or shoe size or being on a diet, can all be considered relevant by the algorithm, as Sandra has also explained. And that might lead it to identify very interesting and perhaps even relevant correlations. But you can also see now how such factors can be proxies for protected characteristics such as gender, and they might cause indirect discrimination. Then there is this other challenge that is related to the nature of algorithms as black boxes. So many people simply do not understand how algorithms work or how they generate output. And we've noted that down here as the transparency and the explainability challenge. And fifthly, there is another important explanation for why algorithmic decision-making is increasingly creating discrimination. And that is that it allows decisions to be made at a very high speed and at a very large scale. And you can see that very clearly in personalized advertising or in price setting on the internet. So if there's something wrong with the algorithm, that means that it will have a huge impact. And finally, it's often very difficult to find out who is responsible for any flaws in an algorithm-based decision. So perhaps that's the person who decided to use an algorithm in the first place, but perhaps it's the person who sold a data set, or it might be the ICT people who have been training the algorithm, or the person who has actually eventually made a decision, or all of those together. And especially if this is related to this transparency and explainability challenge, I think it will be clear that this really sets a challenge in knowing whom to address when algorithmic discrimination arises. And with that, I'll hand back to Raphaële again.
So because of the risks and challenges that Janneke described just now, gender equality and non-discrimination has a very big role to play, as you can see. And so a vital question is, therefore, is EU equality law well equipped to tackle algorithmic discrimination? And this is what our next section is about. Our report shows that there is a number of important gaps and difficulties that arise with the legal framework in place in the EU. And therefore, there is a risk that certain forms of algorithmic discrimination fall into the cracks, and victims might be left without any legal remedy because of that. The first type of difficulty that arises relates to the scope of EU equality law. So to echo Sandra's presentation, yes, we have a good legal framework in place, but there are also important gaps in this patchwork. Algorithms are increasingly used, for instance, to personalize offers and prices, for instance, based on profiling. But the fact is that EU equality law doesn't cover disability, sexual orientation, age, religion, or belief outside the realm of employment. So here you can see a first gap in the patchwork. In addition to that, the protection of gender equality displays also problematic exceptions. For instance, the media, also advertising and education are domains in which gender equality law doesn't apply under in the EU framework. So algorithms play an increasing role in these three sectors. For instance, for advertisement targeting or candidate selection, and therefore these exceptions are also problematic. And lastly, even in the realm of the labor markets, where the protection provided by EU equality law covers all the grounds that are mentioned in Article 19 of the TFEU, the legal guarantees against discrimination and for equal pay only apply where workers have a working contract and where they can be qualified under the EU definition of workers. So this could lead to specifically digital gender pay gap where platform workers are not considered workers or employees in the sense of EU law, and thus a form of digital labor market segregation, for instance. The second type of difficulties is that of shoehorning algorithmic discrimination into the conceptual and doctrinal categories of EU equality law, because, as Sandra mentioned, they do not provide a great fit. And this is because the framework was conceived for human types of discrimination. So one of the mismatches arises, for example, because of the proxy and correlation challenge, which Janneke previously mentioned. And this is because machine learning algorithms are trained to recognize patterns in large data sets. So even if a programmer removes labels which are considered sensitive, like sex, race, age, etc., the machine will still be able to identify related patterns through correlated variables, and therefore discriminate based on these criteria. For instance, research has shown that an algorithm that was used to predict which candidates would be most appropriate for job tenure, this piece of research found that the algorithm was discriminatory because it used the distance between workers' home and workplace as a predictor for job performance. And that was because it was able to infer membership of an ethnic group based on residency data. And because of institutionalized racism and how it is spatialized in society, how it shapes the urban organization, for example, that specific residency group had corresponded to an ethnic group which had less resources because of institutionalized racism. And so the algorithm, the prediction it made, were highly biased. The fact is that discrimination does not exactly happen on grounds of a protected characteristic anymore. So it is difficult to find that causality relationship between a protected ground and a given treatment, as is required for a finding of direct discrimination. So it poses difficult questions regarding the degree of overlap which is necessary between a proxy and a protected ground for a qualification of direct discrimination to arise. And to just mention one example, in Janneke Gerards, the court has said that an applicant's country of birth did not suffice in itself to justify a general presumption that that person is a member of a given ethnic group. So in other cases like DECA, for instance, the court said that sex or pregnancy is a direct proxy for sex, and therefore direct discrimination arises. But in Janneke Gerards, it said exactly the contrary thing. So it is difficult to know when a case of algorithmic discrimination will be considered direct or indirect discrimination. What we found in the report is that as a result of that uncertainty and in that difficulty of showing a prima facie case of direct discrimination, the category of indirect discrimination is likely to become a conceptual refuge. But it comes with other challenges, and not least an open pool of justifications and a proportionality exercise that is difficult to conduct, and also risks leading to a systematic trade-off between accuracy and performance on the one hand, and social justice on the other. In turn, this will raise essential questions such as how much disadvantage is a particular disadvantage and how much equality is enough equality, which are questions which come up again and again in the court's proportionality test. A second mismatch that we have found in the report is the question of the performativity of algorithmic discrimination, or what other scholars have called emergent discrimination. And that is the risk that new patterns of systemic discrimination emerge based on aggregate social sorting performed by predictive analytics, by algorithmic profiling, and by algorithmic decision-making. And as you know, AI is highly deterministic because, as Sandra said, it basically relies on past data to predict the future. And therefore, algorithms perform a form of social scoring, which relies on behavioral data, like your eating habits, your sleeping habits, your sports habits, hygiene, etc., which could lead to pervasive socioeconomic consequences for social groups that are not protected under EU equality law. For instance, emergent discrimination based on socioeconomic status. It could also be discrimination based on dominant body norms, for instance. And because the list of protected grounds in Article 19 of the TFEU is an exhaustive list, as you know, there is little scope for adaptation here. Of course, we could talk about Article 21 of the Charter, but there again, there are limitations. Third conceptual mismatch arises because of increasing opportunities for granular profiling, which are triggered by algorithms and data mining strategies. And this is likely to give rise to intersectional discrimination. In addition to that, intersectional discrimination is already pervasive in society, but because it is not legally recognized as such, it risks being amplified through feedback loops. For instance, in a study about commercial face recognition, which Janneke already mentioned, the highest mistake rates pertain to the faces of racialized women because they were, one of the explanations could be at least, that they are less represented in the data sets that are used to train the machine. So what you see here is that the lack of participation and representation opportunities in society, which is already worse for intersectionally marginalized groups, but which at the same time remains invisible because these groups are not, this form of discrimination is not legally recognized and these groups are not very visible in society. That leads to the algorithmic invisibility of these groups, both in the literal as well as in the figurative sense. So algorithmic discrimination challenges the unidimensional or single axis understanding of discrimination that prevails in EU law. And the problem is that the Court of Justice has largely failed to recognize the issue. And we could mention here the Paris case that was decided in 2016, for example. Finally, a last mismatch relates to the prevailing doctrinal test in EU equality law, and I have already hinted at that. But classifying algorithmic discrimination becomes really challenging because algorithmically supported decision-making systems directly affect individuals. But to do so, they embed structural patterns of discrimination and they perform them further by using them as a basis for future decisions. So predictive analytics algorithms mix characteristic elements of both doctrines and blur the lines between direct and indirect discrimination. And to conclude this section on EU equality law, the last type of difficulty, or a third type of difficulty, is of procedural nature. As has been mentioned before, there's a lack of transparency in algorithmic profiling and predictive analytics systems. Because machine learning algorithms are highly complex, not explainable, sometimes they are also protected by IP rights. And so arises the black box problems. In these conditions, it is very difficult to establish a proof of discrimination or even a prima facie case of discrimination, and especially direct discrimination. And as Janneke mentioned, allocating responsibility and legal liability for algorithmic discrimination will be also a challenge because of the fragmented nature of the chain of actors and legal regimes that are involved in the creation of AI systems, and because human-machine relationships are very complex. Here you can think about automation biases and the question of how to assign agency, for example. These difficulties which I just exposed related to the EU level, and now let's look at the picture at national level. Over to you, Janneke.
Thank you very much indeed. It's a good idea also to see how all of these algorithmic challenges are dealt with on the national level, and whether there are any ways that on the national level, these problems that are inherent to EU non-discrimination law are somehow overcome. And in our report, we have been looking into this based on expert reports for a variety of countries, so 31 in total. And what we can see first, and that might be important to note too, is that we can see many usages of algorithms already in a variety in fields, both in the public sector and in the private sector, and ranging from social welfare policy to banking and insurance. So that means that algorithmic discrimination is certainly a risk that is very close to our own homes too. But what we've also seen when studying the expert reports is not only that algorithms are very much present in almost all the European states, but also that they bring along many of the challenges that we identified. So the experts actually noted many examples reflecting the problem of biased data, the lack of clarity about the workings of algorithms, and the problem of being unable to identify who can be held responsible for discriminatory algorithmic output. And experts also have reported that algorithms can cause discriminatory effects, but these may be very difficult to detect. And indeed, that has been highlighted already also in the discussion. So I'm sure that this really is a very important problem we have to deal with also on the national level. And finally, many experts have noted that the digital gender gap may be an important cause of algorithmic discrimination. So in many countries, ICT professionals are still overwhelmingly male and white, and women and minorities are seriously underrepresented. And if you remember what we've been saying about the risk of human bias creeping into the development of algorithms, you can imagine that that is a real problem too. So what we have luckily seen also in the expert reports is that there is slowly this emerging general awareness of this kind of challenges. So policymakers, scholars, and well, also the general public have started to realize that algorithms are there and that they do entail risks. But what we also have found is that that awareness has not yet translated into much specific action in the field of non-discrimination. So there's certainly well, a flurry of activity in a more general field of ethics and public values, but policy documents and soft law instruments hardly ever address specific issues of discrimination. And even if European scholars increasingly look into European instances of algorithmic discrimination, they still often have to focus on American examples. And actually we did ourselves in the beginning of this presentation. So there's clearly still a lot of work to do here. And the point is, and that's perhaps even more important, is that there is also still a relative lack of formal legal responses on the national level. So in by far the most states, it's supposed somehow that well, general equal treatment law will suffice to deal with algorithmic discrimination. But of course, general equal treatment law in many countries is merely a reflection of the EU directives. And many of the shortcomings of that particular legislation also can be seen to be mirrored at the national level. And there might be some countries where this is compensated for instance, by specific legislation on consumer protection or perhaps on criminal law provisions. And we also have seen national experts report that data protection legislation can help address some of the challenges of biased data and use of sensitive data in training or in feeding algorithms. But still, it's not very clear yet to what extent this specific legislation can really help protect against algorithmic discrimination. And the reason for that is that the experts have been able to identify only very few relevant court cases that actually deal with algorithmic discrimination on the national level. And of course, the lack of such cases can easily be explained by the very same challenges and risks that we have mentioned. So in particular, the experts see difficulties in enforcing non-discrimination legislation because of the difficulties involved in detecting algorithmic discrimination and in identifying responsible actors. So in fact, that sketches a rather bleak picture of how algorithmic discrimination is currently being dealt with on the national level. But there are also some more promising developments to be mentioned. And to explain this, and as the final part of this presentation, I would like to hand over to Raphaële again.
Thank you. So let us finish on a positive note. AI, in fact, also brings with it a number of opportunities in relation to combating discrimination, which society should be able to harvest. And this is what we argue in the report, if it invests in putting in place the right legal safeguards and the right public policies. And we show in the report that the regulation of AI poses the question of interdisciplinarity, and this has been mentioned already in the discussions. But we think that to tackle algorithmic discrimination, we need a threefold approach, because law alone cannot solve the problem entirely. So on the slide, we have a triangle with three items. And the first argument that we make is that fixing the technology means fixing the biases in society through knowledge discrimination. So knowledge is our first item here. And this means dedicated training. This means diversifying professional communities, etc. And this is a very important part of the ex-ante work that needs to be done. The second item we have on the slide is non-discrimination law, or law in general. It has a big role to play, and perhaps as we mentioned, as was mentioned earlier, hand in hand with data protection law, for example, and other regulatory regimes like competition law. And we think that non-discrimination law should be reformed to provide a better fit to algorithmic types of discrimination. And for instance, in the report, one avenue for that we mentioned is that we need to extend the scope of EU equality law. And in order to tackle the gaps in the patchwork that I have mentioned earlier. And there is another legal solution which we propose in the report. And this is to use and revisit the concept of instruction to discriminate as a way to foster a more prevention-oriented regime towards tackling algorithmic discrimination. And I think we'll be happy to come back to that in the chat, in the discussion that will follow the presentation. The third item that we have on the slide.
Raphaële, I'm sorry to interrupt. I'll have to ask you to wrap up in 1 or 2 minutes, if that's okay.
Sure. I'm at the end of the slide anyway. Technology is our third item, and we can come back to that afterwards as well. But the solution that the holistic framework that we propose in the report is entitled Protect, and it's based on a series of 7 key actions: prevent, redress, open, train, explain, control, and test. And I think we'll be equally happy to talk about that later. But just as a last point for this presentation, it is also important to note that AI does not only entail challenges, it also means opportunities for combating discrimination. For example, for the detection of discrimination in algorithmic and human decision-making, we could make use of auditing algorithms. Because the involvement of algorithms in decision-making potentially increases the replicability and the accuracy of decision-making compared to the human brain, this could be a solution. But to conclude, there is a need for synergies between a collective societal reflection on tackling social inequalities as a solid underpinning of the legal framework, and then reflected in tech solutions. And this is a prerequisite for technology to work towards solutions against algorithmic discrimination. And in that, we think that a human-centered AI is not sufficient, but what we need is a social justice-centered AI. And the last word goes to Janneke.
Which is really a last word, because we just wanted to thank you for paying attention and for listening to us. And of course, there will be many questions, and we know we have precious little time to address all of those. But I hope that many of the answers to any questions you might have can also be found in our thematic report, or the special report that is now called actually by the European Commission on algorithmic discrimination in Europe, which is also available open access online. So with that, I will quickly stop sharing my screen and looking forward to answering any questions you might have.